So my presentation today is titled Copyright as a Barrier or Catalyst for Free Speech and Entrepreneurialism. So let's talk about what copyright is. So as a beginning place, in the U.S., copyright grants protection to any original work of authorship fixed in a tangible medium of expression. U.S. copyright gives owners several broad, exclusive rights and then carves out a number of exceptions. And let's talk about that in a little closer detail. Copyright gives authors, now that's a very broad term, and we mean writers, photographers, film producers, composers, computer programmers, so authors is very broadly understood. And we give them several exclusive rights. In other words, the right to exclude, the right to stop other people from reproducing, preparing derivative works, distributing copies, and publicly performing and publicly displaying the work. Now, these exclusive rights are transferable and assignable. And if you remember from property class, we often use the analogy of a bundle of sticks, that property rights are a divisible bundle of sticks, and copyright is no different. These rights can be pulled apart and transferred and assigned to different individuals. You can assign the right to reproduce to one individual and the right to publicly perform to another. Now, unless otherwise agreed in writing, works created by an employee are generally owned by the employer. So while we're talking about copyright, let's talk about where it comes from. U.S. copyright is authorized, gets its authority from the Constitution. And there are actually two pieces of the U.S. Constitution that I want to discuss. The first is where the Copyright Act authority comes from, and that's specifically Article 1, Section 8, Clause 8. Now, Article 1, Section 8, Clause 8 empowers both copyright and patent. And I have on the screen highlighted the particular words that associate with copyright. And that is that Congress is empowered to promote the progress of science. And I talk in my IP class that science historically meant learning, and so that actually is copyright, and that is not patent. So useful arts, on the other hand, that are patentable devices. So copyright authority comes from the power of Congress to promote the progress of science by securing for limited times, and I have that underlined, and I'll discuss that in a moment, securing for limited times to authors the exclusive right to their respective writings. I have underlined limited times because within the grant of authority is a limitation. So it is not an unfettered right. It is a limited right, and that flows from the constitutional language. The other constitutional provision that I want to highlight is the First Amendment. And the First Amendment to the U.S. Constitution actually has 5 rights within it, but only one is relevant for today's conversation, and that is the free speech. So Congress shall make no law respecting the abridging of freedom of speech. Now, there is an inherent tension between the Copyright Clause, which gives a copyright holder the ability to stop somebody from speaking, to stop somebody from expressing themselves, and the First Amendment that says Congress shall make no law abridging the freedom of speech. Let me give you a little bit of background on copyright policy. Conventional copyright theory authorizes what we call a limited proprietary right. So it's a limited right for creative works. Now I'm going to use 2 new words. I'm going to talk about non-rivalrous and non-excludable, and I'll explain both of these. Conventional IP theory, conventional copyright theory, says that these copyrighted works are non-rivalrous and non-excludable. So as an intangible thing, they are non-rivalrous. Well, what we mean by that, non-rivalry means any product or service that does not reduce in availability as people consume it. So if I consume music, it doesn't diminish or reduce the amount of music that's available for other people to consume and enjoy. So creative works are non-rivalrous. They are also non-excludable. And non-excludability refers to any product or service that it is impossible to provide without being available for many people to enjoy. And classic examples of non-excludable public goods would be a lighthouse or a dam or national security. And what that means is that once you've created a lighthouse and it is functioning as a warning to certain mariners, others are also benefiting. You can't stop national defense from protecting everyone. It either protects everyone or no one. A lighthouse either is available for everyone or for no one. And because creative works are essentially a public good, we need exclusive rights to prevent what they call the free rider problem. And a free rider problem is when other people who don't pay into the system are able to benefit. And when you have free riders, it in turn disincentivizes the production of products. So the free rider problem would defeat the incentive to produce creative works. Therefore, we have intellectual property rights that step in to prevent the underproduction of valuable works. They step in and, in essence, give a monopoly power to the creators, because the creators bear costs that imitators would not have to bear. So exclusive rights are granted to incentivize production and public dissemination of private creative works. Now, why does this matter? The reason I'm setting the stage with this background is to illustrate that intellectual property rights and copyright in particular are created for a purpose. These property rights, these limited property rights, are given for a reason. They are instrumental. They are an instrument to an end. The end is more creative works for the public. So copyright always balances interests. Copyright policy balances the interests of creators, of users, and the public. It's a delicate, ongoing balance. And the first Copyright Act looks radically different from the modern Copyright Act. So the first Copyright Act of 1790 provided that copyright protection applied only to books, maps, and charts, and for a 14-year term that was renewable. The modern Copyright Act of 1976 applies to a much broader array of works. So it's not just books, maps, and charts. It is now music, it is sound recordings, it is photography. So it's a broader range of products, and they last substantially longer. So the first Copyright Act was for a 14-year term that could be renewed for a second 14-year term. Today, the modern copyright lasts for the entire life of the creator plus an additional 70 years. So modern Copyright Act is the product of much debate and much compromise. It's trying to balance public and private interests. And for today's conversation, I want to highlight two of these interests. There is a free expression interest and a business entrepreneurship interest that I want to discuss. So copyright is both described as the engine of free speech. That language actually comes from a Supreme Court case that the Supreme Court has recited again and again. Copyright is the engine of free speech. It incentivizes the creation of expressive works. But at the same time, it can be a tool of censorship. It can be an exclusive right to stop people from using creative works. So copyright has the power to foster or thwart new businesses. And I want to walk through a couple cases to show you what this is looking like in the modern day. So before we end our conversation about policy, I'm left with a couple of questions that I want to highlight. First, is there any cause for concern about the current contours of copyright? If copyright is a balance, do we have that balance right? Is copyright okay? Is it doing a good job at its end goal of incentivizing the creation of more works? Is copyright the catalyst that we want it to be, or is it a barrier, or do we think we have the balance right? Now, I want to say that we've always had this ongoing tension and this balance. There is certainly nothing new in today's age. At the dawn of the internet age, policymakers had to face important new questions. For example, how should we limit digital copying by networks like Napster and Grokster? It feels like so long ago that Napster was all the rage, and courts had to grapple with how do we handle these digital files that by copying them and transmitting them, they do not degrade, they're not like the risks attendant with people recording on an analog off of the radio is not the same as people sharing near perfect digital copies with each other. So courts had to grapple with what do we do with Napster and Grokster and similar networks. Another question they had to face is what type of liability should internet service providers, ISPs, face for defamatory content on their networks? If a website is responsible for the content that users put up, does it lead to a chilling effect where website operators may choose not to put up and open up these websites for users to comment? So do we shield, do we provide protections to internet service providers or not? And then other novel questions of cyber squatting and domain name disputes. So new questions have been a challenge for policymakers as new technology has emerged. So copyright and new technology have had a dance for years. This is nothing new. And copyright is inextricably intertwined with these new communication technologies. They go hand in hand. New communication technologies lie at the intersection of free expression and culture and the commodification of information and knowledge. How do you make money on this? How do you commodify it? So there's been this ongoing tension. Now, today's presentation is slightly different from the traditional law school classrooms. This is my scholarship, and so I want to be very clear and manifest that I'm making a legal argument here. And so rather than just a neutral presentation of the law, I acknowledge that I am coming at this with a particular lens and argument. And I submit that copyright creates winners and losers in the marketplace. Now, it is not always clear a priori, ahead of time, if a new communication technology is going to be legal and permissible. New communication technology developers, we could cite Sony with the DVD or the VCR players, Napster, Grokster, Aereo, and if that name is new to you, I will discuss it in a moment. Google, YouTube, these should be household names. These new communication technology developers have often faced costly and protracted copyright litigation. I mean, Sony and Google each had over 8 years, nearly a decade of litigation before their technology was affirmed through the court system. Now, I want to highlight that there are opportunity costs associated with this protracted litigation. It is hard for us to know exactly not just the cost of litigation itself, but the lost opportunities. What other inventions could these companies have invested in if they weren't having to invest in litigation? So there are opportunity costs, which we cannot ignore. So the more resources we have protected, another term could be locked up, but the more resources we have protected by IP, there is a collateral impact on innovation. So the more IP protection the more information that is protected by IP, in turn decreases the available resources in the public domain from which others can draw. So copyright can be used to lock out competition. So there's some concern of anti-competitive behavior as an exclusive right, as a right to exclude, as a right to stop. Copyright can be used to deny a competitor access to what antitrust law calls an essential input. A copyright holder can deny a competitor access to copyrighted works. Now, copyright is different, and I want to emphasize some of the differences that copyright has from other forms of intellectual property like patent. And there are two key differences. First, copyright is so easy to acquire. Copyright attaches at the moment of fixation in a tangible medium of expression. It does not require registration, and it does not require notice on the work. Patent, on the other hand, is a vetting process with the patent office, and it requires time, money, and expertise of a patent attorney to help acquire it. Similarly, trademarks require vetting at in front of the Patent and Trademark Office, and often the guidance and assistance of an expert in the registration process. Copyright attaches at the moment of fixation in a tangible medium of expression and does not require registration, and it does not require notice. And it lasts substantially longer than other forms of intellectual property, such as patent. Patent lasts 20 years. Copyright lasts the entire life of the author plus an additional 70 years. So copyright is fundamentally different from other forms of intellectual property. Now, building on my argument, I want to talk about the value and importance of entrepreneurship. Now, this might seem obvious, but I want to make sure that I lay a sufficient predicate for my argument. Entrepreneurship is essential for revitalization, economic growth, job creation, and technological renewal. The role of technological progress in economic growth cannot be ignored. According to the Obama White House, from 1948 to 2012, over half of the total increase in U.S. productivity, a key driver of economic growth, has come from innovation and technological change. Technological change is huge. It's so important for economic growth. What else is important for economic growth is startups. Startups are one of the biggest drivers of innovation. Startups are also more likely to produce what we call disruptive technologies, game changers in the way we operate. We can think of Uber, we can think of Tesla, we can think of all kinds of startups that provide disruptive technologies. That's good. On the other hand, startups are also more likely to face a lawsuit because of their disruptive technologies. And such a threat of a lawsuit can be an existential threat to the survival of the firm. Litigation costs can bankrupt startups. And so these lawsuits are a big threat. So we've talked about entrepreneurship, we talked about startups, and also I want to talk about how this fits together with free expression. Copyright, as we said, was the engine of creativity, but now it can be a means of controlling free expression. I would argue that creativity and innovation go together. Imagination and innovation are inextricably intertwined. could give you an illustrative example of internet curators. Like if you want to look at the website Pinterest, that allows individuals to crawl through the web, finding images and things that they like, and to electronically pin them to their pin board. Such curation devices are incredibly popular, but their legality is far from clear. Promoting free expression is intertwined with promoting innovation. The internet is we've said that new technology is not new and that copyright has often had to balance new technology, but I would say that the internet is leagues ahead and is quantitatively and qualitatively different. The internet can democratize free expression. It is a bi-directional communication tool. A unidirectional communication tool would be like the TV or radio, that the content producers push information to the viewer and the viewer passively receives it. The internet is fundamentally different because you can both be a reader and producer at the same time. So it's a bi-directional communication tool. So the internet has changed the landscape because everyone can now participate. Rather than it just being a few content creators that created content for internet or for the TV and radio, the internet allows everyone to be a creator. So now let's look at some recent cases. I want to highlight 3 areas of the law: fair use, safe harbor, and statutory licenses. If these are new terms for you, I will walk through these slowly, so not to worry. But what I want you to understand is that these are intended to provide legal protections, and they can be protections for entrepreneurship and for free expression to flourish. So fair use, online safe harbor protection in the Digital Millennium Copyright Act, and compulsory or statutory licenses are intended to protect entrepreneurship and free expression. But what I want to illustrate through some recent case law is how unpredictable they are. And the unpredictability can have a chilling effect on free speech and entrepreneurialism. So I said that I would walk through each of these in turn. So let's look at the first one. What exactly is fair use? Fair use is a legal doctrine that can help promote free expression by permitting the unlicensed, you didn't have to ask for permission, the unlicensed use of a copyrighted work. The Copyright Act sets out a 4-factor framework for determining if something is a fair use. And these are 4 factors. The first is the purpose and character of the use, including whether the use is of a commercial nature or is for nonprofit educational purposes. So how are you using the work? The second one is the nature of the copyrighted work. What is the copyrighted work? Is it a highly factual creative work, or is it or nonfiction or fiction? Is it published or unpublished? What is the copyrighted work? The third factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. This is a multidimensional. Amount and substantiality both has a quantitative and qualitative component. So quantitatively, how much did you borrow? Did you borrow 1%, 10%, 50%, 90%? Quantitatively, how much did you borrow? But the amount and substantiality also has a qualitative dimension. Even if you borrowed 5%, was it the heart of the matter? So qualitatively, did you steal the goody parts, the best parts? So how much did you take? And then the fourth factor is what the courts have described often as the most important factor, and that is the effect of the use upon the potential market for or value of the copyrighted work. So what is the economic harm? So these 4 factors are balanced. So no one factor is conclusive, and there are no presumptively safe or unsafe uses. There are no presumptively fair or unfair uses. The fact that it is for educational purposes does not presumptively per se make it fair, and the fact that you are using it for commercial purposes and making money off it does not make it presumptively unfair. So courts must fully consider all of the factors on a case-by-case basis. And as you might imagine, a case-by-case analysis means that it's very hard to know ahead of time if a court is going to agree that it is a fair use. And Professor Lawrence Lessig has famously said that fair use is notoriously little more than the right to hire a lawyer to defend your right to create. So fair use can be a shield, it can just be an unpredictable shield. And so I want to walk through several recent cases to illustrate the unpredictability. So there were a pair of cases that came out of the Second Circuit that were the Authors Guild versus the Hathi Trust and the Authors Guild versus Google. And in both of these cases, Google was working with some libraries to digitize, to mass digitally scan the thousands of books in their collection. And the copyright holders argued that this was infringing, that they were digitally scanning them and making them available on the internet. The courts in the Second Circuit concluded that this mass digital scanning of the books was a fair use when it was used for two purposes. First, a full text search, and when it was used to provide electronic access for disabled patrons who couldn't read the print version. The courts concluded that a searchable full text database was a fair use because it was, and this is a legally significant term, transformative. It was so different, so being able to search a book was so different than just being able to read it. So that transformativeness goes to the first factor. And then for the fourth factor, and the four statutory factors, the court concluded that there was no harm to the market for the original books since users of the database could not view a work in its entirety, that they were only viewing the snippets of that were returned in the search function that they had, whatever they had searched for. So we see that there are a pair of cases out of the Second Circuit that say that this aggregating digital scanning of material can be a fair use. But I also want to highlight another case that also comes out of the Second Circuit. And here we had a commercial enterprise, so it was a business, and it was monitoring and aggregating internet news. So it was monitoring and aggregating internet news and was offering that to sale and searchable for its consumers. The court concluded that this was not a fair use. The court concluded that they were only searching a limited, what they called a fairly limited number of online sources, and were putting them together. The court said that pulling together some online news and making that searchable was not transformative. So here you have a smaller slice of searching and aggregating that was not found to be a fair use. And recently we have out of the Second Circuit, the Southern District of New York, it's called Fox News versus TV Eyes. And here we've also got a news monitoring and aggregating service. But here they were not internet, like the last case, but it was rather TV and radio news that they were aggregating. And this was found to be a fair use. However, pulling together the information into a searchable database was a fair use, but there were several features that the court found were not a fair use. So archiving the information was not a fair use. Emailing and sharing your search results was not a fair use. Downloading it. So there were certain features that were found not to be a fair use. So what do we make about this? Well, it looks like the creation of a comprehensive database that's intended to curate, organize, and provide easy access to a large amount of information that it would be otherwise difficult to find, like Google did, is a fair use. However, once you pull all that information together, allowing people to do other things with the information, like archive, download, email, might not be a fair use. And if what you are aggregating out of, if you are taking a limited slice of information and aggregating that, that might not be fair use either. So what do we make about this? Well, it looks like the rules for when online content aggregating is okay or not okay is far from clear. So that has, and this is part of my argument, collateral impacts not only on businesses that would want to provide this service, but also on our free speech and free expression interests. So I promised you that I would talk about fair use, safe harbors, and statutory licenses. So let's look at online safe harbors. The Digital Millennium Copyright Act, the DMCA, provides protection for ISPs and websites from liability for monetary damages for copyright infringement, direct infringement, vicarious infringement, and contributory infringement. But to be within one of these safe harbors, you have to be involved in one of the enumerated functions, like your website has to, or your internet service caches information, or you are in the business of placing information online at the direction of users. So the DMCA, which is codified within the Copyright Act, it's Section 512 of the Copyright Act, it provides immunity from copyright liability when the internet service provider either doesn't know or doesn't have reason to know that they are committing infringement or aiding users. So to be protected from liability, internet service providers have to stop and prevent infringement once they receive notice of it. The Copyright Act, the Digital Millennium Copyright Act, also requires internet service providers to adopt and implement what they call a repeat infringer policy, a way to stop somebody from being a repeat infringer. So to stay within a safe harbor. Now, a safe harbor is kind of a nautical metaphor. In nautical terms, it's a place where a ship can be safe from stormy weathers. Well, similarly, an internet service provider or a website can be safe from infringement if they do certain things. The certain things include stopping and preventing infringement and stopping repeat infringers. So I have a couple cases that I want to show you about how unpredictable ahead of time this protection can be. Most of us have probably heard of YouTube, and if you have spent any time on the YouTube channels, you've probably seen things that you think could be infringing. Well, content owners agree with you, and they have sued websites like YouTube for infringement. YouTube and similar websites allow users to upload and share video content. YouTube rarely creates its own content. It's just a platform that allows others to upload. And the plaintiffs and the copyright holders were arguing that there was infringement of their copyright because users were uploading video that either publicly performed, publicly displayed, or reproduced their copyrighted works. The courts have found that these types of websites are protected by the DMCA safe harbor. Now, this is important. Service providers, YouTube, cannot bury its head in the sand. But just generally knowing that there can be infringing material on YouTube is not enough to strip YouTube of its DMCA safe harbor protection. So if they know that there's infringing material, they've got to take it down. But just generally knowing that there can be infringing material on YouTube isn't enough to get YouTube in trouble. So that was the precedent cases. Now there are two cases that I want to talk about that have changed the landscape a little bit. The first is BMG rights versus Cox Communication. Cox Communication is a cable company that also offers internet. It is an internet service provider. It was recently hit with a $25 million jury verdict plus $8 million in attorney's fees. So a $25 million jury verdict because it was not within the DMCA's safe harbor protection. And the court found that it was not within the safe harbor protection because it, according to the court, did not reasonably implement a repeat infringer policy. It did not stop repeat infringers. BMG was able to show that Cox had been sent over 700,000 warnings about possible infringers, but only terminated a handful of accounts. Cox argued that the people who were just alleged infringers by the copyright holders, that's not enough. That the copyright holder alleges that they are infringers might not be enough. The court disagreed. The court concluded that the internet service provider did not have to wait for a user to be adjudged by a court to be infringer. It was enough that Cox just had knowledge or thought they were an infringer before, and that was sufficient for them to take action. This is an Eastern District of Virginia case, so this is only at the trial court level in the U.S. federal court system. This is up on appeal to the Fourth Circuit, and it's going to be very interesting to see how this plays out. So this is one of my cases to watch, because if your internet service providers are having to step in and to police before somebody has been adjudged to be an infringer, this could be a game changer for internet service providers, because being within the safe harbor protection is huge. And if they are stripped of their safe harbor protection, they are going to change their conduct to make sure that they are within the safe harbor. Another recent case, and this actually came out just this year, was a copyright holder versus a company called Zazzle. Zazzle allows users to take an image and to upload it to Zazzle's website and then have it published either on a tote bag, a t-shirt, a coffee mug, a number of different merchandise options. Zazzle is far from unique in the marketplace. There are a number of websites that allow you to custom print images on all kinds of merchandise. But we have a recent case out of California where Zazzle was sued and received a $460,000 jury verdict because of copyright infringement, and the court found that it was not eligible for a safe harbor. And here's how this one played out. To be eligible for the safe harbor, the question was whether the company had the right and the ability to control the end user's conduct, whether to stop the infringement. Zazzle argued that it's a largely automated process, that consumers upload a picture of their puppy, then they have it printed on a mug, and they go about their day. Zazzle says they never really see the picture of the puppy. They don't know who holds the copyright to it. They don't know if it's a fair use. They don't know if it's a licensed use. Zazzle says we are not in a position to know. The court disagreed. The court concluded that a website like Zazzle has the right and the ability to control. The fact that they've automated it is their choice to take it out of their hand, and that they should be able to step in. And the court concluded that the safe harbor does not apply. So this is going to be very interesting to see how websites respond to this liability. Because Zazzle made the argument that it's hard for them to know if somebody has a licensed right to use an image, whether they took their image or whether they are the copyright holder to the image or whether they have a license to it. Companies like Zazzle have little way to police that, but in light of a $460,000 jury verdict and attorney's fees, it'll be interesting to see how companies like Zazzle respond to this. So these safe harbor protections are unpredictable. And the third area that I want to talk about is compulsory licenses. This is a little technical, but let me give you a broad overview. The Copyright Act establishes a compulsory license. Compulsory license is a forced license. It means that the copyright holder can't tell you no, but you have to pay them for their use. So it's a compulsory license. It's a compulsory in the sense that the copyright holder can't deny you access, and it's a license in the sense that you then have to remit a statutorily set royalty payment. There is a compulsory license for cable systems. Let me give you a very quick history recount of how cable came to be in the U.S. Between the 1940s, 50s, and 60s, cable was an emerging technology. The way cable initially began was out in the either rural areas or mountainous areas of the U.S. where broadcast over-the-air radio and broadcast waves had a hard time reaching, if you could imagine in a mountainous area, reaching the valleys below. So you had these companies that would set radio towers or broadcast collection towers at the top of mountains, would collect the broadcast signals, and then would remit the signals to individuals living down in the valley areas through coaxial cable wires. So that's how cable initially began. Cable is allowed to retransmit the broadcasts so long as they pay a statutorily set copyright fee. So that's the backstory. Then you have the internet. The internet, again, is a game changer. You have a company called Aereo that was looking to revolutionize the way we watch TV. Their new business platform was to create little individual antennas. And the little antennas sat they basically had a farm of little dime-sized antennas that were setting out, and they were picking up broadcast signals. So broadcast signals are sent out over the airwaves. These little individual antennas captured the signal and would then remit it to the end user, either contemporaneously, so virtually alive, or it could buffer it and record it and save it for a later time, like record it, and then the end user could then ask for the program to be sent later. The Supreme Court concluded that Aereo's service was a public performance. And why does this matter? Well, at the beginning, I said that copyright gives gives owners several exclusive rights. The right to publicly perform is one of those exclusive rights. It means they can stop other people from publicly performing. And the court concluded that Aereo was publicly performing, and therefore the copyright holder can stop them from doing that. Part of the reasoning of the court is that they analogized internet-based retransmission services. They said that looks so much like a cable company. Cable companies publicly perform. Internet looks like a cable company. Therefore, internet also publicly performs. So they drew a strong analogy between the internet retransmission and cable retransmission to say that it was a public performance. This matters because you've got subsequent cases where these internet-based retransmissions say, we are so much like cable that we are within the zone of the copyright holder, therefore we should be within the compulsory license of the cable system. We should just have to pay whatever the statutory rate is. Unfortunately, the courts have not agreed. You've got courts in the Second Circuit, in the D.C. Circuit, in the Ninth Circuit that say internet is not enough like cable to qualify for the compulsory license. So what does this mean? Well, at one time, this is going back into the history in the mid-last century, cable was the new kid on the block, was the new emerging industry. And cable was allowed to develop because it was found to be non-infringing. Then fast forward to 2014, and the Supreme Court says that internet is close enough to cable to be within the zone. But internet is not close enough to cable for purposes of a compulsory license. So internet is too close to cable so that it's within the zone of the copyright holder, but it's not close enough to be eligible for a compulsory license. So it means that internet is infringing and they don't get the protections of a compulsory license. So what I want to illustrate is that these cases are going to have a dramatic impact on the way new technologies are able to package, transmit, and share television programming with the public. So where does that leave us? Well, hopefully I've been able to illustrate through these new cases that courts are struggling to apply the Copyright Act to new technology, to new distribution platforms that were never contemplated when the Act was drafted, these new scenarios. Now, digital media companies, new technology, whether it's the existing companies or the new kids on the block, these digital media companies are going to continue to develop and innovate in ways to distribute content. And the end result is that courts are going to continue to wrestle and grapple with how to apply copyright to these new technologies. So, coming full circle, I would submit that copyright functions both as a catalyst, as an incentive, and as a barrier to innovation and free expression. The policy choices that we make with digital content can promote, enhance, enable innovation and free expression, or it can stop it in its tracks. It can thwart and stymie it. Aereo and companies like that have gone bankrupt because of copyright law. Now, what I want to submit is that free expression and entrepreneurship are a means. They're not an end in and of themselves. Free expression is a means to democratic self-governance. It's a means to pursuit of happiness. It enables a robust marketplace of ideas in the quest for truth. So free expression is a means, not an end. Similarly, entrepreneurship is a means to economic growth and development. So my argument is that it behooves policymakers to recognize and appreciate the powerful collateral effects that copyright policy has on culture, on democratic self-governance, and innovation. So in our ongoing copyright balance, there are inevitably winners and losers. In each of the cases that I walked through today, there are winners and losers. These new disruptive technologies face serious limitations in the face of copyright law. And in the ongoing balance, there appears to be the incumbent forces that are prevailing more often. But what question I am left with is whether the public's interest is ultimately winning or losing. And to come full circle, copyright exists for a purpose. Copyright is instrumental, and it ultimately is to inure to the benefit of the public. And again, is the public's interest winning or losing?